third bucket for this
purpose.
So
in this case, where if the church takes the position, he's the president of the church, the prophet, and church members are asked to contribute tithing based on worthiness. They only get to go to the temple if they do that. They're supposed to get certain blessings. There's never any discussion about how it's going to be used in church doctrine. So if you have that situation, and you get back to what was actually said by President Hinckley, you don't have the example that you give where they said, we'd like you to contribute some money for this, and we're going to use it for this, which is contrary to the normal doctrine. And that answers, I think, my colleague's question. If there's a specific request to use money for X and they don't use it for X, that might be different. But that's not the way tithing is solicited, is it?
Well, yes, and tithing really isn't solicited in the same way as limited purpose funds are, which is why in describing sort of the metes and bounds of the doctrine, I would describe it as tithing refund claims are presumptively covered by the church autonomy doctrine, subject to these two exceptions, and I think that would provide a clear rule, and it would have the incidental benefit of avoiding churches from being in the dilemma that my clients were in, which is they don't want to just rely on an immunity. They want to, they've been accused of wrongdoing and they want to defend themselves. But if you make it crystal clear that there's a broad doctrine with two exceptions, then I think that it's much easier for churches in future cases to say, we're going to get rid of these cases at the threshold. And it also prevents the, opening the floodgates. And Judge Bress asked a question about this as if it were a hypothetical. But since this panel decision, there have been multiple class actions brought against the church, and I don't think it is a problem that is limited to my client. Other churches are here as amici because they're worried about this same thing, and I think the reason they're worried about it is every church has adherents that then lose their faith. Now, if those former adherents came into court and said, well, I want all my money back because, for years I was told I needed to give this money to save my immortal soul, and now I've decided all that immortal soul stuff is bunk. There's no afterlife. This is it. I want that money back. I'm going to Vegas, whatever. Like, if they tried to bring that claim, they would be laughed out of court. Of course you can't bring that kind of fraud claim where you bring in experts and say all this afterlife stuff is bunk. But there's a profound temptation in that circumstance to, go back and fly-spec all of the sermons and say, oh, well, I was told something about abortion, or I was told something about this City Creek project. And, well, in retrospect, I wouldn't have given my money. So I want to do a secular fraud claim instead of the obviously improper religious fraud claim. I think there are good reasons to stop that at the threshold.
Sorry to interrupt you, because I know your time's running short. Can you spend a minute addressing the jurisdictional issue? Because it seems apparent to me that the Church's Council were aware, and just the way that they questioned Mr. Huntsman during his deposition had flagged this issue for themselves, but then it just kind of like petered out. Is there a reason for that? Is there a downside to remanding for additional factual findings by the district court before we take up the merits of the case?
So, if this court can, instantly reconvene the en banc panel after it sends it back to clarify what I think is true and have no reason to doubt, I don't really, I barely have standing to object to that. I think if the consequences of that were that we had to go back to square one or something, I think it was not the best use of this court's resources. I guess, to answer the question, we asked some questions in the deposition. The answers were such that combined with the averments in the complaint, we didn't think we had a basis to question his domicile at the point that he filed the complaint. He alleges he's a California resident, which I know there's kind of these competing presumptions, the presumption in favor of the old sort of domicile, but there's also a presumption in favor of residents being the domicile. As my friend on the other side says, we're miles away from a situation where the only new domicile is a hotel room, and then you add to that the fact that there was a specific allegation that there's complete diversity in the citizenships of the parties, which was a separate allegation in the complaint. I think we took all of that, everything we heard in the deposition. We did not think we had a good faith basis to question what is, this is, it's a weird situation in a sense, because the question is ultimately, although testimony intent is not dispositive, The legal question is ultimately the intent of the person at the point at which they filed the complaint, and we don't think we have any basis to question that. And I would say, maybe this is another reason why the church autonomy doctrine should apply, but, puts a church in a weird position where it has to call its former member a liar, at the jurisdictional threshold, which is essentially what we would have had to do if we doubted his averements in his testimony. Watson has said that jurisdiction is a term of many meanings,
Right.
too many meanings.
Right.
And so I think when you put that more recent observation of the court together with what it said in Hosanna Tabor and what they then subsequently said in Our Lady, I think as a lower court, you do not have to tie yourself to the mast of what the court said in Watson. I think you are free looking at the Supreme Court's...
Although that footnote could also be considered dicta, don't you think?
What's that?
That footnote in Hosanna Tabor could be also considered footnote.
I've read theories that is dictum.
Yeah.
I would take my chances with saying that's a holding, and think that's a safer course than saying we're bound by Watson as the holding.
So, counsel, in this case, if we were to resolve it on what I'll call the first ground, which is the non-constitutional ground, that would be solely a question really of California law, correct? You agree with that?
I would agree with that.
So there are a lot of other states in the country, and I'm curious, would there be other states that define fraud differently that would then, in a sense, bring this case right back to us if it was brought in Nevada or brought in Idaho or Utah? Or do you think that, or do you not see a difference?
I don't see a material difference. I mean, there's probably some state out there that has a funky concept of fraud by omission, but I think, you really don't get a fraud claim anywhere without a misrepresentation.
Does the church have any sense of how many copycat cases were filed against it as a result of the original panel's decision?
Well, there's been at least half a dozen, but most of those have been styled as putative class actions.
Right.
And there's sufficient litigation against them that an MDL has been convened.
Got it.
So that's why I say the floodgates concern here is not hypothetical. It is real, and it's all since the panel's decision in this case.
Are they all California cases, or do they vary?
They're brought
Abroad.
in multiple jurisdictions. So let me just close with one point of context here. I mean, among the problems with this claim is not just that you can't decide it without deciding the definition of tithing, but you can't really decide it without saying that the supreme leader, the supreme religious prophet of a religion with 17 million adherents, basically committed a massive fraud on his followers when he was speaking ex cathedra. Now, I don't think that proposition alone decides the case for the reasons I alluded to in the exceptions, but it sure contextualizes the case and sure makes clear that the autonomy doctrine should apply. Thank you.
Thank you very much.